Sir,
I
I
will.
didn't ask you about any of that. I asked you if you
I
understand
will, however,
Mr. Matson, don't interrupt me. I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying.
let me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me.
All right, folks. Let me set the scene. The case opens with a man who insists he isn't just David Thompson. Oh no, he calls himself a living soul. Already, you know exactly where this is going. One of those sovereign citizen types. The people who think a courtroom is just a stage for their own fantasy. The judge starts simple. He asks, "Are you David Glenn Thompson?" Just yes or no. That's it. But instead of answering, Thompson launches into this bizarre monologue about being the sole allowed to use the name.
I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right. So Sierra will need about a 1-hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
You can practically hear the judge's patience wearing thin. And then, here comes the magic word. The judge warns him, bench warrant. Folks, let me tell you, nothing wipes that smug grin off a sovereign citizen faster than the words bench warrant. 1 second, he's rambling about uppercase letters and some statute nobody's ever heard of. The next second, he's stammering, yes, yes, sure, yes, like a school kid caught red-handed. You could almost see the panic crawl across his face. It was like someone flipped a light switch. Now, let's pause here. For those of you who don't know, a bench warrant is basically the court's way of saying, enough games, you don't show up, we'll have you picked up. It's real. It's serious. And in Thompson's case, The threat of actually being arrested had him snapping into line real fast. But here's the kicker. Even after the judge spelled it out plain as day, Thompson still couldn't resist. He starts whining about being coerced and correcting errors.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names, but any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination, how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right. So the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
It's not about the arrest. It's about the arrest for the violation of probation as well.
All right. The only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was Judge Sloan, and then there was you. I've seen both.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on.
Well, hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation. So the court will conduct.
Let me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded.
Errors on the record. Folks, the record doesn't need correcting. The record is that he owes child support, and a lot of it. The judge finally lays it down crystal clear. This hearing isn't about philosophy. It isn't about feelings. It's about whether he's been paying. And if not, contempt. And contempt of court doesn't mean a slap on the wrist. It can mean jail time. And that's exactly why Thompson's in this mess. He's dodging payments, dragging his feet, and now standing there trying to convince a judge that some living soul loophole is going to save him. But folks, this hearing is about to take a sharp turn, because just when you think Thompson might finally quiet down, he drags in his next wild excuse, and trust me, you're not going to believe what he claims he paid his child support with. So just when you think this guy can't sink any lower, he does. The judge is trying to keep it straightforward. There's a bond posted, there are arrears, and the court needs to decide what to do with that money. Now here's the part that floored me. Thompson says, "Well, I didn't put the bond up. A friend did. I want it returned to them." Folks, let's be real. That bond money? Gone. The court makes it crystal clear. Bonds in support cases can and will go straight to cover child support arrears. The judge practically tells him, kiss it goodbye. Honestly, I almost felt bad for the poor friend who handed over the cash, probably thinking they'd get it back. Imagine lending money to a sovereign citizen. That's like throwing it straight into a bonfire. And then, here comes the comedy gold. Thompson pulls out his evidence. He claims that back in 2017, he sent a promissory note, wait for it that were worth $20,000 in gold dollars, registered mail, to the clerk. And in his mind, that should have erased the debt. A promissory note. Folks, this man really thought he could scribble something on paper and call it gold dollars to pay off child support. I mean, can you imagine showing up at court with monopoly money and saying, "Here you go, Your Honor, debt settled"? That's about how much sense this makes. The judge, to his credit, doesn't explode. Instead, he mutes Thompson, literally shuts him down mid-ramble. And you can feel the exhaustion in his voice when he explains, this isn't complicated. There's a case, there's an order, there's money owed. Thompson hasn't paid. End of story. But Thompson, he can't stop. He keeps tossing around buzzwords. Article 3 court, House resolution, contracts, none of it tied to reality. And by now, the judge has had enough. He lays it out clear. This isn't difficult. You were ordered to pay. You didn't pay. The arrears are nearly $155,000. $155,000. And Thompson's sitting there acting like the problem is capitalization on his name. Folks, it would almost be funny if it wasn't so sad. This isn't about sovereign philosophy. This is about kids, real children, who were supposed to be supported. And instead of stepping up, Thompson's hiding behind nonsense. But here's where it all comes crashing down. The judge makes his final call, and let me tell you, it leaves no room for Thompson's games.